Okay, good morning, good day everyone. Welcome back to our course, The Law on Sales. We are now in 6th installment of our video lessons. Again, this is your host, instructor, lawyer, Professor Lyndon A. Maceren. And we'll continue our discussion on the subject matter of redemption. So there are different types of redemption. First, we will discuss conventional redemption. Conventional redemption only extinguishes obligations that pertains to the contract of sale, but it does not extinguish the contract itself because it applies to the contract of sale. Only applies to a contract of sale. So the contract itself is not extinguished because there is still if the option for the seller to redeem the property. So conventional redemption is conventional taken from the word convene, so meaning it's agreed between the buyer and the seller that the seller will repurchase or redeem the property in the future. So the right which the vendor reserves to himself is to reacquire the property which he has sold, provided the seller will return to the buyer the following, namely the price of the sale, the expenses of the contract, other legitimate payments, the necessary and useful expenses which were made on the thing sold by the buyer, and fulfills other stipulations which may have been agreed upon. So the right is exercised only by the seller, in whom right is recognized in the contract, or by any person to whom right was transferred. So if the seller has transferred to another person, it can still be exercised by that person. It must be in the same contract. So the conventional redemption can be exercised by another person, which is the transferee of the seller, but it must be stated in the same contract. Okay, so let's move on to legal redemption. Okay, let's move on to legal redemption. Legal redemption applies to contracts of sale. So this legal redemption has not been agreed upon by the buyer and the seller, but because of the operation of law, it serves as the right of the seller to redeem the property. So the right to be subrogated upon the same terms and conditions stipulated in the contract, in the place of one who acquires the thing by purchase or by dation in payment, or other transaction whereby ownership is transmitted by onerous title. So the right of redemption is subrogated to another person to repurchase the property from a buyer or from a person who has been paid through dation in pago or by transaction, as long as it's transferred by onerous title. So there are different types of legal redemption. So among co-heirs, so co-heirs, meaning a deceased person has left property to his sons or daughters, then they are now co-heirs. And one of the co-heirs, one of them sold his share to another person. So his co-heirs are now entitled to redeem his share, the share of the person who sold his share of the co-owned property. So among the co-heirs, they can redeem any of the heirs who sell his hereditary rights to a stranger. So before the partition. So the property that their father or their parent or their ascendant left them is still undivided. So the co-heirs have the right to, have the right to redeem whatever is sold by another co-heir. So any of the co-heirs may be subrogated to the rights of the purchaser, meaning who was purchased, the right of the purchaser can be transferred to the co-heirs by redeeming said hereditary right, as long as they reimburse the buyer the price of the same. And what is a redemption period? It is 1 month from receipt of notice in writing. So the notice in writing, meaning that the co-heir is going to sell his share to another person. So he's giving notice, or he's giving the notice that he has already sold his share. So 1 month from then will be the expiry, or the legal redemption, or the right to legal redemption will prescribe. Also, among co-owners, still the property in co-ownership is undivided. So any or all of co-owners sells their shares to a third person, then any one of them can redeem. Any co-owner may exercise right of redemption by paying the reasonable price of property to the buyer. Now, if two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they respectively have in thing owned in common. So pro rata. So again, co-ownership is an undivided property. The co-ownership would exist if a property is undivided and numerous persons own this property. Legal redemption also belongs among adjoining owners of rural lands and urban lands. So in rural land, who has the right of legal redemption? So where piece of rural land has an area of not exceeding 1 hectare, the adjoining owner has right to redeem unless grantee does not own a rural land. So rural land is provincial land or farmland, no? So if there are two adjoining properties and the owner of the other adjoining lot sold it to another person, then the owner of the adjoining property has the right to redeem it in order that his property will now be bigger, no? So who has the right? If there are several adjoining properties, then the one whose property does not exceed 1 hectare. Now, if there are two or more adjacent lot owners who desire to exercise the right to redeem, then the one who has a smaller area is preferred. No? So there are two properties. Okay, that's very understandable. So let us see if two or more adjacent lot owners desire to exercise the right to redeem the property, and both have the same lot area. So the one who can exercise is the one who first requests to exercise shall be granted. No? So whoever first requests. Okay, let's go to urban land. Legal redemption of urban land. So when piece of land is small and cannot be used for any practical purpose, and bought merely for speculation, so both merely for speculation, the owner of the adjoining land can redeem that property. No? Because in the Civil Code, in particularly Article 1623, before you sell your property, you must offer it first to the owner of the adjoining land, meaning he has the right of first refusal. And if you sold it to another person who is not an adjoining property owner, so the better person is the the owner of the adjoining properties. They have the right to redeem. Now, when two or more owners of adjoining lot in urban land desire to exercise the right to redeem, then the owner whose intended use is best justified shall be preferred. So we don't know what is best justified, so they have to present it in court, and the judge will now preside and decide who has the best justified intention. Now, if the sale of credit in litigation. What is this? When a credit is or other incorporeal right in litigation is sold, the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid, therefore plus judicial costs and interest. So this is a proof of credit, no? And it is under litigation and it is sold. So this is only not pertains to credit but also incorporeal rights. The debtor has the right of legal redemption as long as he reimbursed the transferee or the assignee. So the prescription is within 30 days from date assignee demands payment from him. So there are other instances when right of legal redemption is granted, such as redemption of homesteads, Public Land Act, and the land acquired under free patent. Homestead is subject to repurchase by the wife. Legal heirs within 5 years from date of conveyance granted by law need not be stipulated. There's also legal redemption in tax sales. Now, in case of tax delinquency, like when you are a property owner and you fail to pay your real property taxes to the government or to the LGU, so your failure to pay tax assessment, then the property is foreclosed. And the delinquent payer or the delinquent owner has 1 year from date of sale to redeem by paying to the revenue district officer the amount of tax delinquencies and interest or purchase price. Also, this will apply to foreclosure or levy of or seizure of property made by the BIR. So redemption period is 1 year from date of sale. Then legal redemption also applies to in court cases where a debtor has been a judge in court, no? So meaning of judgment debtor, that he's a debtor and now the courts decided that he is really a debtor and he owes the creditor, and the property of the debtor is taken and sold in public auction. So he has 1 year from date of registration of the certificate of sale to redeem by paying the purchaser at public auction plus interest. So that's also legal redemption. Legal redemption also applies in extrajudicial foreclosure. So this happens outside the court. So the foreclosure is made probably by a bank, and because the debtor has not paid his loan, and now the real estate mortgage is sold, no, it's foreclosed. So the security, which is a real estate property, so now it's being sold. So the owner of the property, meaning the mortgager, has 1 year from date of sale and registration to redeem the property, his property. Another application of legal redemption in judicial foreclosure. So this time it's the court who is now foreclosing the mortgage. In this case, no right to redeem is granted to the debtor, the mortgager, except when the mortgagee is a bank or a banking institution, and the prescription is 90 days from the finality of judgment. So if the one who is applying for judicial foreclosure is not a bank, so there's no right to redeem. No. Number 9, when the period of redemption begins to run. So when should it run? No. So the right of, meaning the prescription period, the right of legal preemption of redemption shall be exercised within 30 days from the notice by the seller. So how is it exercised? Of course, tender payment is not necessary, but the offer to redeem is enough. So you have to offer, no, the buyer that you are going to redeem. So there is no prescribed form for an offer to redeem. So a mere letter is, or a verbal is enough. So there is no formal form required. So verbal offer is enough. Hence, it can be through a formal tender with consignation of redemption price within the prescribed period. What is paramount is the availment of the fixed and definite period within which to exercise the right of legal redemption. So that's why tender payment is not necessary, because you can make a tender payment in the court. So that is why consignation is here. Consignation is you are depositing payment in the court. So in deeds of sale, which are not recorded in the register of deeds, unless accompanied by affidavit of the seller that he has given notice to all possible redemptioners. So the right of legal redemption may not be registered in the registry of deeds. So this is what I was telling you about Article 1623. It is mandatory for the right of redemption to commence. So there's a written notice. So if there's a written notice that you will receive, the adjoining property owner is going to sell his property, and he's therefore offering you, if you're willing to buy his property. If you will not exercise that privilege, then within the 30 days, then it is already prescribed. No? So thus the general rule is that actual knowledge, notwithstanding written notice, is still required, except when actual knowledge is acquired by co-heirs living in the same land with purchaser, or co-owner was middleman in sale to third party. So written notice is required, but if there is actual knowledge, then this is an exception. No? And in the case of Cuban versus CA, the court says that Article 1623 does not prescribe any distinctive method for notifying the redemptioner. So it may be enough if there's a text message or an oral or express notice. No? Another way of legal redemption is when there is an option to purchase. So the right to repurchase the thing sold, which is granted to the vendor in a separate instrument from a deed of sale. So there is another deed that the seller and the buyer has executed, and this is the option to purchase, meaning to buy back the property from the buyer. In some cases, this option to repurchase or right to repurchase may be uh, equivalent to a mortgage. So that's why it's stated here equitable mortgage. So according to the Supreme Court, one which lacks the proper formalities, the form of words or other requisites prescribed by law for a mortgage, but shows the intention of the parties to make the property subject of the contract as security of a debt and contains nothing impossible contrary to law. So there is no specific word stated that it's a contract of sale. That probably what's stated there that the property stated in the contract is a security, mere security for a debt, which is stated here. So when that is the case, then it is tantamount to a mortgage. So it's equivalent to a mortgage, not a contract of sale. And when there is equitable mortgage, then it has a contract with right to repurchase. You know? So when a contract has a right to repurchase given to the seller, then it is deemed to be an equitable mortgage. And these are the requisites. The price of the sale with right to repurchase is unusually inadequate. So it is lower than the fair market of the property, fair market value of the property. Then the seller remains in possession as a lessee. You know? So he does not surrender the thing to the possession of the thing to the buyer. Then number 3, upon or after the expiration of the right to repurchase, another instrument is executed extending the period of redemption or granting new period to the seller. So say a period expressed there is not within 5 years. So if that already expires, so they will execute another and extend the period to another 5 years. So that can be done. No? Another requisite that the buyer retains for himself a part of the purchase price. Then letter E, the seller binds himself to pay the taxes on the thing sold. So seller, despite already selling it, he still pays the taxes of the thing. That we're talking about real property taxes. And lastly, the real intention of the parties is to secure the payment of a debt or performance of other obligation. So it is the property which is stated in the contract is not being sold, but it is only to secure payment of a debt. So it's just like a mortgage, no? So in case of doubt in determining whether it is an equitable mortgage or a sale, a retro, so the sale shall be construed as an equitable mortgage. That's the rule. Now, what to look for in determining the nature of contract? So the language of the contract and the conduct of the parties to reveal their real intent. So if the intent was to secure a debt, payment of a debt, then it is an equitable mortgage. But if the real intent is to transfer the ownership, there is a sale. So what's the remedy available to a vendor in case there is doubt of the contract, in the contract? Simply is to ask for the reformation of the contract. If the buyer now or the other party will assent, then it will be corrected by way of reforming the contract. So what are the rationale behind provision on equitable mortgage? Circumvention of the usury law. So by the way, usury law is still under suspended stage. Or then we have letter B, circumvention of prohibition against pactum commissurium. So pactum commissurium is a prohibited agreement. This happens when this means the creditor cannot appropriate the things given by way of pledge or mortgage. So if you have a loan, then you secure it, the property. So this is now, if it's a real estate, then that's a mortgage. If it's a personal property, then that's a pledge. So there is no, if the what is pactum commissurium? If the creditor automatically appropriates these things as an owner, no? So there's no automatic appropriation of the things because there should be foreclosure. So if the debtor or the pledger or the mortgager has not paid the loan, so the remedy of the creditor is to foreclose the property by way of extrajudicial foreclosure or judicial foreclosure. Well, the real intention of parties is that the pretended purchase price is money loaned and the property is to secure payment of the loan. So sale with pacto de retro is drawn up. So again, pactum commissurium is illegal. It is the automatic appropriation of the things by the creditor, which are being pledged or mortgaged. Now the period of redemption, if there is no agreement stated in the contract as to the period, then it would be 4 years from date of the contract. That's the redemption period. But if the period is stated or agreed upon, it should not exceed 10 years. If it exceeds 10 years, then it is valid only for the first 10 years. When period to redeem has expired and there has been a previous suit on the nature of the contract, then seller still has 30 days from the final judgment on the basis that the contract was a sale with pacto de retro. Pacto de retro means the right of repurchase. No? Rationale, there is no redemption due to erroneous belief that it is equitable mortgage, which can be extinguished by paying the loan. That's why there is no redemption. Okay, now what are the effects when there's no redemption made by the seller? Before the NCC's new civil code, so before the new civil code, the Supreme Court in its jurisprudence state that the buyer a retro automatically acquires full ownership. So this is no longer applicable because if the buyer a retro automatically acquires full ownership, then that is tantamount to pactum commissorium, which has been discussed earlier. It is prohibited. No? So under our present civil code, specifically under Article 1607, it requires that there is a judicial order before ownership of real property is consolidated with that to the buyer who is a buyer retro. A buyer retro is buyer with right of repurchase. So how is redemption effected? If a seller a retro must first pay the following. So this is the must pay the price of the thing sold, expenses of the contract, other legitimate payments by reason of the sale, necessary and useful expenses made of the thing sold, valid tender of payment is sufficient, mere sending of notice without valid tender is insufficient. So notice plus payment, no? Because according here, if there is mere sending notice and there's no valid tender of payment made, that is insufficient. So failure to pay useful and unnecessary expenses entitles the vendee or the buyer to retain the land unless actual reimbursement is made. Now what if there are multi-parties or multiple parties involved? So when an undivided thing is sold because a co-owners cannot agree that it be allotted to one of them, then there is a buyer a retro. So the buyer a retro may compel the vendor to redeem the whole thing because the vendor involves co-owners, no? Or co-heirs, though there are multiple parties. So when an undivided thing is sold by co-owners or co-heirs, the buyer who is a retro, meaning buyer who is bound to the redemption, the legal redemption rights of the co-heirs, may only exercise his right over his respective share. A buyer a retro may demand that they must come to an agreement first and may not be compelled to consent to a partial redemption. So we're talking about the whole property here, no? Or not the whole property, but a portion. But let's say there are 5 co-heirs and 4 heirs are sold, and one heir is still holding on to the property, and the thing is undivided. Now he is going to exercise the right of redemption, so he must purchase the share of the other co-heirs. So he cannot be compelled, the vendee cannot be compelled if it's only a partial redemption. So with the remaining co-heir will only exercise to buy only one of the co-heirs' share. So he cannot force the buyer. When rights of co-owners over an undivided thing is sold as regards to their own share, so the vendee, the retro, cannot compel one to redeem the whole property. So this is the other way around. It's now the vendee who cannot compel the redemption of the whole property by one of the co-heirs. Okay. Now, should one of the co-heirs or co-owners succeed in redeeming the property, such vendor a retro or the seller shall be considered as trustee with respect to the share of the other co-owners or co-heirs. So let's say, for instance, there are two co-owners or two co-heirs. The other person or the other heir sold it to another person. So, and then it was redeemed by the co-heir. Now, this co-heir is not considered as an owner because this is still owned by the co-heir. He is just holding on to the property as a trustee. No? So how about fruits? Number one, what controls is the stipulation between the parties as to regards the fruits. If there is none, so if there is a stipulation or there's an agreement, then that controls who owns the fruits. If there is no agreement, then at the time of execution of the sale, a retro, there are visible or growing fruits, then there shall be no pro-writing at the time of redemption if no indemnity was paid by the vendee a retro. So meaning the fruits will be owned to the will belong to the, or inure or accrue to the buyer a retro if he is not paid by the redeemer. So at the time of the execution of the sale, there be no fruits, but there are fruits at time of redemption. So it is now prorated between vendor and the vendee, but giving the vendee a retro apart that corresponds to the time he possessed the land. So it be now prorated, as to how many years you are in possession. So that would be now the basis. So let's distinguish preemption from redemption. Preemption arises before the sale, while redemption arises after the sale. And there is no recession in preemption because there's no sale that exists yet. But in redemption, there can be a recession of the original sale. So in preemption, there is no sale yet. No. So there is no recession. Third distinction, the action is directed against prospective seller, but in redemption, it is directed against the buyer. No. Okay, so that ends the topic of redemption. And we have discussed conventional redemption and legal redemption, as well as preemption and redemption. So when this thing happens and when this can be applied in a contract of sale. So conventional redemption is again agreed by the parties. So right of repurchase. And legal redemption is by operation of the law, and afforded to co-heirs, co-owners, adjoining property owners, and so on and so forth. So this ends our discussion for part 6. If you have any questions, you may write me or text me. My number or my Gmail account, Maceren and macerenlaw@gmail.com. So that ends for now, and keep on studying because knowledge is power. Bye.